I'm Dominic Raeside, and I head the mediation service here at Family Law and Partnership. I take a very family-focused approach. Divorce and separation is a really difficult time for families. It's not uncommon to have feelings overwhelmed by emotion, blame, guilt. Children may feel confused, insecure. So my approach in mediation is to think of it as a family that are transitioning through this difficult stage in their life. And blame isn't part of the discussion that I have. It's very much a future-focused exploration of what's the best it can be. So what I offer is a safe place to have these important decisions and discussions about children's arrangements, the sort of atmosphere that they might experience between their parents, decisions about school options, holidays, a whole heap of issues that are really important and have a profound effect on children's welfare going forward. Well, I will have spoken to the parties individually, and that gives them an opportunity to share any concerns and for me to understand their situation from their individual perspectives before I meet jointly. And that could be around my mediation table, or it could be online. But if you were a fly on the wall, what would you see? I think you'd see a calm, respectful discussion about arrangements for the future. So I think many of my clients might feel anxious at the prospect of meeting around the table with their ex or online. And my skill is about how I manage that discussion, which is a calm, respectful discussion about the future arrangements. And the focus is very much on the future and what's the best it can be, and very much focused on their continuing role as parents to their children. Sometimes in mediation, we'll discuss the interim arrangements and have a plan for maybe 2 or 3 months, and then they will meet back with me to review arrangements going forward. Because what is appropriate for a 2-year-old is likely to be different to what's appropriate for a 12-year-old. So there's an incremental evolving structure often to be discussed. I also meet with children, generally 10 and over, and with the agreement of both parents, because these are important decisions for children and they have a view. And whilst it's no part of my role to ask them binary questions of which parent do they want to live with, mine is a gentle chat, really, about their thoughts about the future. And I often pick up some really good ideas from them, which I'm then able to impart at a subsequent meeting with the parents to inform their discussion about the arrangements that they're having with me. So when discussing finances and mediation, financial discussions, of course, are based on full financial disclosure. So the options available to a divorcing couple wanting to resolve financial arrangements would include mediation, collaborative law, lawyer negotiations, arbitration, or court and court adjudication. In mediation, it's based on the same transparency about finances. So it's important that all the numbers are on the table and they're understood by everybody. But it's not hard-nosed negotiations. They have what they have in terms of capital and income. And it's a sad truth that most families are less well off following divorce because you've got the same money having to manage 2 homes. But again, the drivers are similar, which are about fair-mindedness and pragmatism and working it up to a solution that meets their needs and their children's needs and is fair. That's what we're trying to aim for in mediation. And if they do reach joint proposals, which most of my clients do, then there's always the opportunity to take those joint proposals to their independent solicitors to be advised on them before they're turned into a financial consent order as part of their divorce proceedings.